Hi, thank you for joining our webinar. My name is Jessie Peterson. I'm the Director of Education here at SunRay Construction Solutions. SunRay secures $10 billion annually for GCs, subs, and suppliers. We are a national construction document service. Today's webinar is conducted by the incredible Mark Cobb, a Georgia construction lien law guru. Today's webinar topic is A Contractors, Subcontractors, and Suppliers Step-by-Step Guide to Getting Paid. So without further ado, I'd like to introduce the fabulous Mark Cobb.
Wow, Jesse, that's pretty incredible. I think you're going to be hired by my firm to market me. I think that's fabulous. Today we're going to rush through a lot of things, but a couple of administrative things first, if you don't mind. If you have any questions, please go to the chat box on the right, and then we'll answer everybody's questions at the end of the seminar. I'm going to try to leave time for that. We're going to get through every single question that we can. Don't worry about leaving your name, your company names in question at all. Just ask a question and we'll do our best to answer them for you. Getting started, as Jesse said, my name is Mark Cobb. I'm a construction lawyer in Georgia. I've been doing construction laws basically since 1992 when I started practicing law. I'd gone to Washington Lee University and sort of found construction law to be my niche. My first real client was a large national equipment supplier company, and I had to work with the credit manager to figure out how we could help them get paid. Of course, involved liens, payment bonds, et cetera, et cetera. The credit manager there was pretty phenomenal. She was a great businesswoman. I was a young fledgling lawyer, but I knew the law. So between the two of us, we were able to figure out really something a lot of people miss is how to collect money and how to collect money on construction projects, because there are very unique considerations. So today's seminar, I'm going to try to keep this to about 20-25 minutes. So we're looking at this from 40,000 foot. Every single slide we have could go on for probably an hour. I've done that I think for probably each one of these in larger formats. So we're just going to kind of fly through a few basic things, hope that everybody learns something, and then at the end have the specific questions, and we'll be glad to help you any way that we can. So we're going to be looking primarily at three areas. We're going to look at primary considerations for somebody in the construction industry to help make sure they get paid. They're going to look at what people can do during the project life to make sure they get paid. And then finally, we're going to look at project completion. If you haven't gotten paid, what are some of your options and what are the things that you can do? So preliminary considerations, and it's amazing, people overlook these things, but these are so vital to the risk that you may be exposed to. Number one is building relationships. Sounds easier, sounds like it's common sense, and it is. But I have I'll call her a friend because we're actually friends. She's also a client. The problem is she never needs me. One of the reasons why she never needs me is because she's an electrical subcontractor, and she works only for one of about 6 general contractors. All of these general contractors have worked with her for 10, 15 years. She knows their contracts. She knows their payment history. She knows their reputation. And conversely, they know her. They know the quality of the work that she provides. They know the scheduling. So guess what? She has no payment issues. The only time she's ever had a payment issue was when she went with a contractor she did not know. So it's very important to build those relationships and understand who those people are. Another area where we see a lot of things that happen up front is where people fail to properly define the scope of work they're doing or the materials they're supplying. What we don't want to see are change orders, particularly change orders that are not approved in writing by all the parties. So when you have an undefined scope, a general contractor or an owner may say, hey, you're supposed to do this too, it's included. And you're arguing, saying, no, it's not. Or if I'm going to do that, I need additional money. That's a problem that should be dealt with upfront and really should not become a standard operating protocol for you and your team. A third primary consideration, very, very, very important, and it's so hard to convey this, is understand your limits. I remember back when the Great Recession hit, going to a seminar, and the attorney who was speaking gave all these facts and numbers that said more businesses fail, more construction businesses fail when the economy is good. than when it's bad. Kind of scratched my head about that. I was like, okay, it's the Great Recession right now. I've got 1 million clients that are wanting to file liens, making payment bond claims. They're not getting paid. What does this mean? Well, since that time, we've had some very boom times, and I think everybody on this phone call probably would agree with me. Skilled labor is a significant problem within our industry. So limits mean you can't perform the work, or you have difficulty performing the work, or you can't do it on schedule. It may mean it's a larger project than you're accustomed to. With COVID in particular, we saw supply chain issues. So there are limits. Doesn't mean you're not a good contractor. Doesn't mean you're not a good supplier. Doesn't mean you're not a great business. But when people stretch too hard and too far, they fail. And when they begin failing, it has a domino effect on other projects, because we see clients who will borrow money from one project to pay for another project. Then that first project, they end up getting liens on it, and they then get a bad reputation, and it just snowballs, and they end up not getting paid, and they end up owing a lot of money. Another area for primary consideration is due diligence. Now I'm going to change the screen on this one because I think due diligence is very important. And oddly enough, we have very few clients that do due diligence. With some regularity, I'm not sure exactly what the percent would be, but in 5 to 25% of our cases, a client, particularly a first-time client, will call us and ask for help with a collection matter on a construction project. They don't have the basic information. By basic information, I mean who is the entity who hired them. They might say, oh, it's Stan. It's ABC Contracting. Yeah, it's a starting point. But really, who legally is responsible for that debt? I think I have 2 cases right now where somebody mentioned it was ABC Contracting. Well, you go to the Secretary of State's website in Georgia, and that's where these entities are created and allowed to exist. There is an ABC Contractor, but the problem is there's about 6 of them, and they have different numbers at the end: ABC Contracting 1, ABC Contracting 2, ABC Contracting 3. So you don't know who if you don't know who your customer is or who your client is, then it makes it that much more difficult to collect money on them. So it is very important that up front, every single one of you knows the legal name, knows what type of entity it is. Is it an LLC or an Inc? Because a lot of times we see that too. It'll be XYZ Plumbing LLC, but there's also an XYZ Plumbing Inc. Which company is your client? It's helpful to have the tax ID number, because that too helps to prove who you're actually working with and who actually owes you the money. Similarly, owner's name on the project. The owner's name and contact information is very vital, and some contracts have it, but a lot of contracts don't. And particularly for suppliers, you may not have the information. It is vital you get that, and in a few minutes we'll talk about what you can do after the project. But having that information helps you collect your money. It's not uncommon that we recommend a client with payment issues contacts the owner. So, before you hire a lawyer, before you do this, let the owner know you're not being paid. Let the owner know. The owner may be holding back retainage. The owner may be aware of some payment issue or some other issue with a general contractor. Let them know there may be a way to amicably resolve this without spending any money on legal fees. Another thing for due diligence is look at your customer or your clients or your contractors or your owners' prior or pending lawsuits. That can tell you a whole bunch. There's not much worse when we get a client who calls us for the problem, and we begin doing this, and we begin doing background checks on their client or their customer, and we realize that they have multiple pending or prior lawsuits. There was one a few years back that was building long-term care facilities. They were a nationwide company, but basically they go into a state, build 5 or 6 or 7 of them, leave the subcontractors and suppliers high and dry, and then just retreat back to their home state. And if there was a complaint, you had to file that in their home state, and it just was very, very difficult to get money from them. They owed so many people, and that was just part of the business practices. They were just they intentionally wanted to stiff people. So if you have an idea of the lawsuits, and Google can give you a good idea about this, then that can prevent a problem up front. Similarly, those of us in Georgia, we have the Atlanta Business Chronicle. And while it doesn't cater necessarily to construction, it does have a lot of articles about construction. So you can get an idea about the businesses and the lawsuits. Prior liens, that's an easy one. So you or your lawyer may have to have an account with the Georgia Clerk's Authority. They're the people who manage material liens in the state of Georgia. But when a client does ask me to do due diligence, the very first thing that we do is look to see how many liens have been filed against their projects or how many liens they have filed themselves. And every scenario is different, but it can tell you the good contractor, no liens against them. Those who have payment problems tend to have a lot of liens against them. So it's very important to understand that. Similarly, if that contractor files liens themselves, that tells me they're not doing their due diligence on the owner. So maybe the contractor is a legitimate contractor, but the owners that they're choosing to work with maybe don't have the financing or can't pay. And that can affect those downstream too. So very important to understand how many liens there are. Also, bondable. You know, as we all know, and this could be a very important, significant separate conference, but bondability goes to someone's credit rating, their reputation, and their ability to complete a project. And so if you're working for a GC who is bonded on other jobs, there's a greater likelihood that you'll have a successful project and get paid. So that brings us to the last point on this one. You want to look at the success of past projects. I have actually called other owners to say, hey, how was XYZ contracting? Did they do a good job for you? Were you happy with them? To get that information, to give my client the confidence that, yes, we are going to do this project and we're going to try to avoid any payment issues. Then also upfront, the big thing is contracts. It is very important that you understand the risk involved and you understand your potential liability. Are there liquidated damages or they're not liquidated damages? Are you responsible for all damages or just damages resulting from some defect? Another area that's a big problem but very important is understanding the payment process. Look in the contract. If it says your past due payments are subject to interest, that's good news. If it doesn't, then it's probably bad news for you. We even like to specify specific interest rate amounts. I was drafting one yesterday and I put 1.5% per month. That's 18% per year, roughly. Also, payment process. What happens to amounts in dispute? If they say there's a partial defect or a failure to deliver, how do you handle that dispute and how is it resolved? Does it go to an architect, some sort of person who's making initial interest? Does it go to the owner? Who is there and who will advocate on your behalf? The dispute process is very important. We see in most construction contracts, most large ones at least, requiring arbitration. Arbitration is a much more effective way of dealing with disputes. They can be resolved much more quickly and generally tend to be less expensive than actually going to litigation. Mediation, which is a voluntary settlement, it's where parties come together and there's no settlement unless the parties agree to it, but mediation is the most effective. It is the quickest way, and I realize with money, it's about cash flow, it's about getting the money in, and mediation is also very inexpensive from a legal standpoint. So we suggest people put in their contracts that if there's a dispute, mediation first, then arbitration. But you need to know the deadlines, you need to know the jurisdiction. Again, the example I used earlier of the long-term care facility contractor, you had to go to their state if you wanted to sue them. You can change the jurisdiction to Georgia or where you're located. And also your contracts ideally would all be governed by the laws of the state of Georgia, not somewhere else. It's never too late to ask for a personal guarantee. It sounds silly. Suppliers out there, I know you're probably asking for personal guarantees, and that's great. Subcontractors can too, and Georgia will enforce that. We have created subcontract agreements where we build in a personal guarantee in that same document. It's there, it's not hidden, but many times people don't read the contracts the way they should. And so later on, when there is a payment dispute, we point to the personal guarantee provision, and guess what? Our clients get paid because nobody will be personally liable for that debt. Joint check agreements. It's so funny when there's a payment issue and I say, well, contact the owner to see if there's a joint check agreement. The owner will say, we can't do that. They can. but it's easier and clearer and cleaner if you put it in the contract that you have the right to go to the owner, get a joint check agreement, or in the event the owner doesn't want to do a joint check, the owner can pay you directly to make sure. So those are some things, you know, under the project life, and again, each of these points are pretty huge, but under these points, under these are things you should do during the project life. Once you've been committed to supply or work on a project, what can you do? The number one thing is you need to comply with Georgia's statutory notice scheme. If you are a contractor, a general prime contractor, or if you are a subcontractor or supplier working directly for the general contractor, this does not apply. You do not have to comply with the statutory notice scheme. However, if you are working for a subcontractor or supplying to a subcontractor, so if you're a sub or a supplier to a subcontractor, then you need to comply with the statutory notice scheme. And that's one of the many things that SunRay does, and they do very well. The notice scheme is basically you have to give notice within the first 30 days that you begin working on the project or begin supplying the project to let people know that you're doing what you're doing. So you have to send a notice to owner, that's to the owner of the project. You have to send a notice to contractor, that's the general contractor, that says, hey, we are a supplier to, you know, ABC electrical company. If we don't get paid, we're preserving our lien rights. If you're required to comply with the statutory notice scheme and you do not, then you do not have lien rights. So it's very important to get that notice out. Look at it from a practical standpoint. The owner has an obligation to make sure the money flows downstream. So the owner knows who the contractor is. So he can make sure he pays the contractor. The contractor is his agent, and this contractor knows all the first tier subs. But neither the owner nor the general contractor know the subs or the suppliers or those who are further downstream. So that is the purpose of this notice. And when you send that notice, it greatly reduces your risk of non-payment because the owners are tracking the payments to make sure they go downstream. Georgia does have preliminary liens. They're a beast that's not often used, but for those of you who do need them, and I tend to say they're needed for large amounts, and when you don't have a relationship with the contractor or with the owner. So for example, we have a large lumber company, their lumber, you know, they do multifamily housing. They tend to supply lumber in the millions of dollars. We do file preliminary liens on their behalf just to make sure they get paid. But preliminary liens have to be filed within 30 days on the first day they work. So it's the same deadline as the statutory notice scheme, but two separate beasts. Another thing, while the project's going on, it's so important that you timely submit your pay apps and you complete them properly. Otherwise, it will delay payment. And so it's very important that your staff is trained and they know what they're doing, and you monitor it from a payment standpoint. And then this one's a little tricky, lien waivers. On most large projects, you will be required to provide a lien waiver. Georgia only has one form, well, really it's two forms. One's for interim and the other's for final. So they're slightly different, but they're substantially similar documents. They are conditioned upon payment for the first 90 days. But on the next day, they convert to unconditional. So if you submit a lien waiver and you are not paid, you have 89 days to file a document called an affidavit of non-payment. If you file that affidavit of non-payment, then the lien waiver is void. On the other hand, if you fail to file the affidavit of non-payment, then your lien waiver on the 90th day converts from a conditional on payment to an unconditional lien waiver, and you cannot file a lien as to those amounts. So when you have someone with slow pay, you need to be monitoring that and regularly filing these affidavits of non-payment. Now, in project completion, this unfortunately that you're probably going to be calling us or having questions because you haven't gotten paid. There's been some slow pay, there's issues. And so, typically one of the first things we are going to recommend is to file a materialman's lien, particularly if you're a subcontractor or you're a supplier. The reason for that is you have a contract claim with whoever hired you, presumably the prime contractor, let's say. That contract claim is great. It'll help you get paid. But if you're able to file a materialman's lien, then you're able to also get the owner, make the owner responsible for payment of your work or your materials. And so that materialman's lien is almost like a after the fact personal guarantee. It's really it's really favorable to increase payments. So liens are very important. And in Georgia, they must be filed within 90 days of the last day you worked. Now, on all Georgia government projects, this is state of Georgia, municipal and county projects, you can't lien, but you can make a payment bond claim. And that has the same deadline as the liens. You must file your payment bond claim within 90 days of the last day you worked. And that payment bond is an insurance instrument that guarantees payment, essentially. So instead of filing a lien, you have the right to go after an insurance company for the payment. I'd like to point out that on most large projects, multifamily housing projects for sure, even large big national companies like Walmart, they usually require payment bonds on their projects too. So if you're not paid, you have a contract claim against whoever hired you. You also may be able to file a materialman's lien and rope in the owner, and you may also be able to make a payment bond claim. So make sure you maximize all your rights. Liens are generally valid for 364 days from the date of filing them. But in order to make them last longer, you must, quote, commence an action. And that can get technical, but basically it's filing a lawsuit, or if the contract requires mandatory arbitration, you can make a demand for arbitration. And so you want to make sure that you do that within time. So just a quick review of the important deadlines. You want to send that notice to owner, notice to contractor within 30 days from the start of work. If you file a preliminary lien, you need to file that within 30 days from the start of work. If you file a lien waiver and you haven't been paid, you have 90 days to invalidate that lien waiver by filing an affidavit of non-payment. If you're done with your work and you still haven't been paid, you have 90 days from the last day you worked to file a lien. If there's a bond on a municipal project or a payment bond on a private project, you have 90 days from the last day worked to make that bond claim. In order to make your lien last more than a year, and bonds have similar but not necessarily the same deadline, but roughly you will have to commence an action, and that's generally within 1 year. I would like to point out in Georgia there's an exception if the owner or the GC files a notice of contest of lien, that 1 year is reduced to 60 days. And then in order to perfect that lien after you file suit, you must follow up in the lien record by filing a notice of action, which says, hey, we filed a lien. Within 1 year, we filed lawsuit, and here's where we filed lawsuit, so that those who are examining the title, banks, for example, or real estate attorneys, can say, hey, there's a lien on this project we need to address. Oh, look, it's been more than a year. Oh, but wait, they filed suit. Okay, we still have to address this lien. You'll probably want to have a lawyer help you with that. That is all I had officially. I wanted to scoot through this very quickly, but I think we'll take some questions. Jesse, do we have any questions that have come in?
Well, first of all, thank you so much, Mark. That was incredible. It was packed full of information for us, so I appreciate that. For the questions, yes, I do have one that came through. It says, as a general contractor, when should I file a notice of commencement?
Great question. Georgia statute says you're supposed to do it within 15 days of starting the project.
Okay.
And so that's really the question. You really can't do it too early, because if you do file it late, those subcontractors or suppliers might not have to comply with that. And so the sooner you can, the better.
Okay, great. And then the other question that just popped up is, it's really frustrating if I haven't been paid. I have to pay for a lien. Can I get the fees reimbursed on the lien? To mean, can you include the attorney's fees or filing fees on that?
Sure, great question. So there's two different answers. Well, there's lots of different answers, but the first place we're going to look at is your contract. If your contract allows for you to recoup attorney's fees and legal costs, then it's going to be much more likely that you will recover that. keep in mind we're a little different than the English system. In England, the loser pays for both parties' cost. In America, each party pays their own cost. And so it is contract dependent, and really it is judge dependent too. So what we tend to see is if there's a legitimate dispute, I say you owe me money, you say you don't owe me money, we both have a legitimate cause, judges tend to not give attorney's fees. On the other hand, if it's clear cut that someone's taking advantage of another, then the judges tend to award attorney's fees. That goes to the contract claim. It generally will not go to the payment bond claim. So if the owner steps forward and wants to pay, you're less likely to get attorney's fees covered. Now, we do get calls from closing attorneys saying, hey, I'm about to sell this property. I notice you have a lien. What's the payoff amount for this lien? When we do that, we include interest and attorney's fees and everything we can get to. Generally, they're not disputed. Generally, they're just kind of paid at that point. It's interesting. So it is possible, but I'd say it's less likely against the owner.
Okay, another couple of questions came through, so
Good.
let's see if we can answer some of these. We did not do an NTO, and the sub told me to send a letter to the GC for intent to pay. Informed that the NTO was not completed, what can I do?
Well, I'm not quite sure what the intent to pay would be. So can that person answer? Are they a subcontractor? Are they working directly for the GC?
That's kind of what I'm, if that was your question, and you can respond back, that I think it says we are the supplier.
Okay.
I think that was that one. Thank you.
Okay, so if an NTO wasn't sent, the first thing I'm going to do is to see if the statutory notice scheme applied to you. And what I'm going to do is I'm going to see if the owner or the GC, first of all, filed a notice of commencement. I'm going to see, getting back to an earlier question, if they did it within 15 days. And I'm going to see if it met the statutory requirements for being a notice of commencement. So for example, on private projects, GCs have to file a meets and bounds description with a notice of commencement. I'm going to say about a third of them do not have that. They have a street address instead. So in that instance, I would tell the supplier, you didn't comply with the notice requirements. However, they didn't either, so they're moot. You can still go after your payment bond. I mean, you can go payment bond or the lien.
Okay. Another question came through. Can you explain the enforceability of a primary lien versus a mechanics lien, or just the general difference?
Maybe it's supposed to be preliminary lien.
Okay, maybe that's what they meant to type in there.
Sure, preliminary lien. Okay, so there are ways that owners can defeat liens, and one way they can defeat that lien, and it's sort of technical and very specific to an individual situation, but a contractor can provide an affidavit that says we've paid everybody. And in that case, if a lien comes in after the fact, that lien, that owner might have a defense of having to pay that lien. So if the contractor does that affidavit within 30 days of project completion, but then the lien claimant files a lien 60 days afterwards, that owner may say, hey, we don't have to pay that lien. If they have filed a preliminary lien, then the owner, that affidavit will not defeat that particular preliminary lien claimant's lien, even if it's filed after that affidavit is signed. And so that's why we recommend it on large dollar amounts, maybe where there's a question about credit rating, or you have no relationship or don't know who this party is.
Okay, another question that just came through. How can we charge interest if the customer tends to pay us when they get funded by the owners?
Well, you kind of can't. Well, I mean, it depends what your contract says. I mean, you certainly could, if they agreed to it, you could put that in there. What that question is going to is pay when paid, pay if paid. You really want to avoid those at all cost. And 10 years ago, suppliers and subcontractors had little leverage in defeating those. We now see they have a lot more leverage. First of all, courts are getting loath to enforce those provisions because it's just not fair for suppliers and subcontractors to not get paid. And also, due to issues such as skilled labor and issues like getting materials timely, preferred subcontractors, preferred suppliers can negotiate those out of the contract. That's what we highly recommend trying to do that.
Okay, I think that's all the questions that have come through. It's a little challenging to see in this little window that pops up here, but if we didn't answer any of your questions, or if you think of another question that comes about, please give us a call, reach out to us. We will share to answer any questions for you to the best of our ability. All right, are you able to go to the next slide for me, please, Mark?
Yes.
All right, so who is ready to win a gift? We are testing your knowledge. I know some of this information was already on his presentation, so take a look at these questions. If you're able to enter into our chat here with the correct information, I will go ahead and send out some gifts to you. We'll get some of your information from you. So the first question is, as a subcontractor or supplier, when should I file a notice to contractor? And then the next question, when should I send a Georgia's claim of lien? So take a look at those, see if you guys can figure out those answers, those responses, and we'll go from there. Mark, can you go ahead and go to the next slide for us, please?
Sure.
All right, so if you guys take a look at this, if you scan this QR code, it will take you to some of the information for SunRay, some of our resources. It will kind of give you some information to stay organized, know your deadlines, and figure out how you need to secure your lien rights. So go ahead and scan that QR code to access these incredible resources. Mark, can you go to the next one for me as well? All right. So this is our new service that SunRay is offering. SR Receivables will be handling your collections for you now this year. So we are here to help get you guys paid. So go ahead and check that out. Let us know if you have any questions, or we can get you guys started on that. The next slide, please. All right, so our next webinars with Mark, the first one will be what happens after I record my lien and how do I get paid? That's going to be on March 12th at 11 a.m. And then the next one will be getting paid faster with liens, bonds, and contracts, and that's on August 12th. All right, if you can, go ahead and register for free at sunraynotice.com/education. Yes, so the live seminar, the in-person seminar. So if you guys are in the Atlanta area, we are lucky enough to be able to host with Mark a seminar for you guys. It's how to get paid faster with liens, bonds, and contracts. That's going to be on August 23rd. It's going to be from 9 to 11. There might be a little bit of spillage after that. So you can go ahead and register at sunraynotice.com/seminar. All right. So this QR code, if you guys can go ahead and scan it and get us a review, it takes about a minute of your time, if that, but it helps other contractors like yourselves hear about us and get some of this information that Mark was able to present to you all. I believe that is all we have with you guys today. Thank you again so much for your time. You guys are incredible. Thanks for everybody who attended. Again, thank you, Mark. You really are wonderful. Again, if you guys have any questions, please don't hesitate to reach out to us. And we hope you all have a wonderful, wonderful sunny day. Thanks again.